Welcome to HR Insights, the podcast. Topical discussions with and for our global HR community.
Welcome back to HR Insights. Today, we are turning our attention to a topic that has been firmly on the agenda for HR leaders across the UK, that of employment law. The Employment Rights Act has been described as one of the biggest shifts in workers' rights in a generation. After months of discussion, anticipation, and lots of preparation, some of these changes are now very much a reality. Joining me today is Paul Burton. He is the Legal Director and Employment Solicitor at ViewHR and brings nearly 20 years of experience advising organisations on employment law and workplace issues. In the first of our two-part conversations, we're looking at what has already changed, the lessons employers can take from recent employment cases, and also what HR teams need to be paying attention to right now. The last thing I would say is this is obviously very much geared towards the UK, but for our international audience, what I would say is where countries like the UK lead, a lot of other countries follow. So what you're seeing happen over here could well happen further down the line in the location that you're in. It's a really good listen. Paul is someone with a huge amount of experience, and I look forward to talking to him, and I hope you enjoy the show. Thanks ever so much. Paul, welcome to the show. How are you today?
I'm good, thanks. Thanks for having me, Stuart. All good, and nice to see it's a little bit cooler this week, so much more comfortable.
Yeah. It's much cooler, and we can joke a little bit about this, but you and I now have tried to record this. I think it's our third attempt. Is that right?
It is, yeah, third time lucky.
Yeah, we've had a few technical issues in recording this, so we're hopeful that we've got this right now, and we're all here. But look, for our audience and for everybody, do you want to give a little intro to you and your background, Paul?
Yeah, of course. So I'm Paul Burton, ViewHR. So personally, I've been an employment solicitor, specialising just in employment for 20 years this year, actually. I literally at ViewHR, I'm one of the solicitors here, and I support both internally my colleagues on the employment law side of things, but more importantly for clients, anything to do with employment law. In terms of me personally, I live down in Dorset. I'm a bit of a sports fiend, so I like playing lots of sports. Cricket was my big one when I was younger, eventually my back gave out. So these days I do a bit of tennis and some cycling. Yeah.
Very, very nice. So we'll joke. I think we joked last time actually about being a mammal. So you're very in that camp. Is that right?
I'm afraid I am. Yes, very much a middle-aged cyclist. Yeah. Yes, who does wear lycra occasionally. Yeah.
Yeah, no, that's fair. What about paddle? Have you got into that? I know that's the booming sport at the moment.
Very recently tried it out, yes. We're lucky we've had a new Dorset paddle centre open about 10 minutes from where I live. So, I've been down there a couple of times. It's very interesting. I played a bit of squash when I was younger, in sort of my teens, 20s. So it's a bit of a combination of tennis and squash. So, yeah, it's quite good.
Yeah, I've only played it like once or twice, but it feels like it's everywhere at the moment. And I don't know whether that's because it's much easier to play than tennis, or but it seems to be the sport at the moment.
It is. I think it's the fastest growing sport in the UK apparently in the last couple of years.
I think you're right. Yeah, I think it is.
It may be. There's courts certainly popping up all over the place. And it's indoors. It's you can fit more courts in a space because they're smaller. So and there seems to be, as you say, I think it's a bit of a snowball effect at the moment because it's growing. More and more people become aware of it, and at some point it will plateau. But yeah, looks good at the moment.
Yeah, very good. Well, we're not here to talk sport all day. We're here to talk employment rights act, which your professional expertise that we want to sort of dive into. So look, we know there have been some changes in the UK, and I think, even when I think about our international audience, a lot of what happens in places like the UK or the US, when something like this changes, that is a sort of a precursor to things happening elsewhere in the world as well. So do you want to give a little bit of a summary of the changes, I suppose, that are happening?
Yeah, so
December
December last year, what's known as the Employment Rights Act 2025 came into force, and it's probably the largest piece of legislation, I would say, in employment law, certainly since the Equality Act in 2010. Some of your listeners might know about that, and even the 1996, unfortunately same name, Employment Rights Act,
Right.
because it's bringing in a number of changes over, really from early this year, right through until next year and beyond potentially. So I can talk about some of the changes that have come in so far. The first major change was in February, on the 18th to be exact, and that was all around trade unions. So
Right.
some sort of industrial action reforms, which is probably to be expected with a Labour government coming in, without getting political, but that's the sort of thing we'd expect them to do. And so they've made it basically easier again after some restrictions were brought in previous governments for industrial action to take place. So there's now what's called a mandate for them to take action once they've had a vote. Has been extended from 6 months to 12 months, and the notice period that they have to give to the employers is reduced from 14 to 10 days, as well as some voting changes around the minimum level service levels for say public, important public services such as NHS, emergency services, etc. So that was in February, and there's more trade union changes to come. And then April was the next sort of big raft of changes at the beginning of the financial year.
Yeah.
Firstly, statutory sick pay. So two major changes to that. What's called the waiting period, which was 3 days, has now been removed. And also there was a minimum earnings threshold below which you literally weren't entitled to statutory sick pay. Now everyone's entitled to statutory sick pay, but if you're below that threshold, then you get 80% of your earnings. Then some family-friendly rights, as we call them, changes to paternity leave and unpaid parental leave. They became day one rights. So previously you had to have a qualifying period of work for them. Now they are right from day one of employment. Sexual harassment, there's changes to law there, and again there's some more coming up. But the one in April was around making it a qualifying disclosure as part of whistleblowing. So now sexual harassment is a specifically named in the legislation that can be a protected disclosure. And then finally, on collective consultation, and what that means is if you've got lots of redundancies, 20 or more, or you want to change lots of employees' terms and conditions, there's a procedure to go through. If the employer gets that wrong, they can be penalised. But it was previously 90 days per employee affected. It's now 180 days. So theoretically, it can become very expensive because you could be facing pretty much 6 months' wages to pay to each affected employee. So they're the changes. Yeah. And then the one other thing is a whole new body came into effect, the Fair Work Agency. That came into being in April as well.
Yeah. Okay. Quite a lot to unpack.
A lot to unpack.
Yeah. Quite a lot. Now, before we go into some of those points individually, do you find that these changes are going to affect certain types of businesses more than others? So, is it companies that are more, I suppose, public sector in orientation, or do you find that this is going to be more, say, manufacturing, or does it genuinely affect sort of white collar workers as well? You find
a lot of the changes will affect every type of business. Right. Some of the changes, in particular ones coming down the line, there will be certain sectors that will be affected more. But for example, the ones we've talked about, sick pay. Unfortunately, no matter what sector you work in, you as an employer, you're going to have people go off sick. Yes, it is true that some sectors have historically been affected more by higher sick rates, but then again with the paternity and parental leave changes, that no matter where you work, what sector you're in, you're going to have people who need to use those rights. So, in essence, yes, it's going to affect all sectors, all types of business, public, private, going forward. Yeah.
Yeah. Okay. Yeah, fair enough. Well, let's unpack the statutory sick pay. I want to touch on that first. So, if we talk to us about the waiting period, what it was, why it existed, and why it's so relevant that it's disappeared now.
Yeah. Well, the first thing to say is there are, of course, a lot of employers, and this is where it was much better generally in the public sector, but still a lot of private sector employers do it as well, have contractual sick pay. So, we must make it clear that it has been the case that a lot of people did get sick pay from day one, but it was contractual sick pay. Statutory sick pay, which is the bare minimum, which every employer had to provide, there was a 3-day waiting period. And what that essentially meant was if you worked for me and you were only entitled to statutory sick pay and you took a couple of days off because you had a heavy cold or something or, whatever, then I didn't have to pay you anything because there was a 3-day waiting period. You weren't entitled to the statutory sick pay amount until day 4 onwards. Whereas, of course, that's gone now. So now it's from day one. Yeah.
Right. Okay. And from day one, does that mean you need to be, I suppose, prescribed off by a doctor, or what does that mean exactly then?
No. So that hasn't changed. So people can still self-certify for the first 7 days. So after 7 days, you need a what we call a fit note from your doctor. But what employers certainly feared when the legislation came in, and obviously it's early days, we're only a couple of months into, so it'll be interesting to see what the statistics are like and sickness absence levels. But what some employers were fearful of was of course, if people knew they were going to get some sort of pay in those first few days, they're much more likely to take the odd day off, or 2 days here than perhaps previously. Yeah.
Okay. And did this mean that, I suppose, absence management becomes ever more important to a company? Is this something they should be focused on a little bit more than they maybe were?
Yeah, absolutely.
Okay.
A lot of employers will have in their contracts of employment, we may have return to work interviews with you when you've been off sick and that. But actually in practice, a lot of them, for understandable reasons, you're busy, you're doing other things, just didn't carry those out. I think they're much more important now. As you mentioned, you've got to be a lot more proactive in absence management. So if people are off, have a return to work interview with them. Find, from a supportive side of things, see what's happened, why they've been off. It might be something very minor and that's fine. But also keeping, analysing, how often people are off. Do you have those persistent short-term absences, which, as I said, some employers are fearful that are going to increase. So, that is something to definitely do.
Yeah, makes perfect sense. And if we move on to the paternity, we're sort of going through these one by one. We're going to the paternity side of things. Now, obviously, these are now, I suppose, potentially day one rights. What were they before?
Right, so they were actually slightly different.
Right.
The qualifying period for paternity leave was 26 weeks, so 6 months.
Okay, long time, really.
Whereas for unpaid parental leave, it was a year. So now I must make it clear, because I even had colleagues who were confused about this when the law first came in. This doesn't change the pay side of things. Okay, so there are still different qualifying conditions for pay, but this is much more importantly about leave. So if you join me day one, then you are entitled. If you become you're going to become a father, then you're entitled to that leave from day one. Yeah.
Yeah, and parental leave in the UK, what does it stand at the moment?
So unpaid parental leave again. That will be from day one as well. It's not as well used because the key word there is unpaid. So of course there are some employers who will go above and beyond the bare minimum of the law and pay. But it is unpaid leave, and it tends to be for when your children are perhaps, you need to take time off because not necessarily they're ill, but they need some support in something. And what it means is through the child's lifetime, up until they're an adult, parents can take time off as parental leave, and they are protected in terms of their job and that if they do so. But as I say, it is unpaid unless the employer decides to go over and above.
Yeah, fair enough. But paternity leave is normally roughly 2 weeks, is it? Is that right? Paternity leave?
It is. There has been talk about it being, increased, but at the moment, yes, it's the minimum. Again, employers can offer more, but the minimum statutory amount is 2 weeks.
Yeah, I'd say that's what I'm hearing a bit more noise on from employers rather than maybe legislation. I do hear a few employers are potentially looking at that as a way of differentiating themselves from other companies in terms of benefits.
Yeah. And the pay these days, whilst it's still predominantly going to be the most important thing that people look at, more and more benefits are something that employers really need to look at to as you say, differentiate themselves from other employers in the recruitment market.
Yeah, completely. And if you're an employer, is the biggest thing here about updating policies and that kind of thing, or are there other factors to think about and consider here?
I would say yes. Updating policy is always important.
Yep.
You must make sure that that's in place correctly. But I'd say more important is the training of your managers. Making sure that they are updated and are aware of the changes. Because you might have some very good managers who've been around for years and they've always known that you have to work for 6 months or a year before you get these rights. And what you don't want to do is someone join you, come to the manager and say, good news, my partner's having the baby now, and I need my paternity leave. And you turn around and say, no, you're not entitled to that. You've only just joined us, because then straight away you're into a problem. So making sure not just your staff are aware of their rights, but your managers know about them and know how to deal with requests when they come through.
Yeah. So ultimately, it's not just a policy change. There's a training and development angle to this, or a learning and development angle to this as well.
Yes. I always think that the management risk side of things is much higher almost than the policy updates. Yeah.
Right.
I would hope that a lot of HR experts will be able to do obviously the policy updates fairly easily. It's all the stuff that comes around it, like the management training.
Yeah, that makes perfect sense. And again, as I said, we're going through these sort of line by line a little bit, but the sexual harassment disclosures are now protected under whistleblowing legislations, I suppose.
Yeah.
There are a couple of questions here. Why is that so important? And can you also talk us around what the changes are here, just so that everyone is crystal clear on what this is?
Yeah, so we've got whistleblowing legislation in place already in the UK, and what that means is if an individual says to their employer, "You're doing something wrong," traditionally it would be you're breaching health and safety, or you're breaking a law of some sort, and then they suffer a detriment. So it could be anything. It could be like, you haven't promoted me, or you haven't given me a bonus like you have, something negative, or they're in fact dismissed and they say it's because of that disclosure. Then straight away they're going to have claims around that. And what the government have done, they've now added sexual harassment to the list of things that can be what we call a protected disclosure. Yep. And what that means in practice is a few things. Firstly, it gives an individual another route. So up until April, it was the case that if you had suffered sexual harassment, then you had to bring a claim under the Equality Act as a discrimination, harassment as a form of discrimination, or maybe you even resigned and claimed constructive unfair dismissal. Now it's been added to the whistleblowing legislation. Firstly, the person doesn't have to be a victim themselves.
Right.
So if you see someone else being harassed and you say to the employer, "Well, this is going on," and then you think you suffered detriment or dismissal, you could bring a claim then. So that's the first big thing, is it expands the remit, for want of a better phrase.
Yeah.
And then secondly, it does open up, if the employer does get it wrong and doesn't deal with it properly, it does open up, as I say, not only further claims, but even types of claims. So there's something called interim relief, which is very technical and has to be claimed within 7 days of the individual sort of bringing the initial whistleblowing claim. But essentially, at its worst for the employer, if they succeed in what's called an interim relief claim, then they can claim their wages, even if they've been dismissed, all the way up to whenever a final hearing to determine the whole claim takes place. And unfortunately, with the tribunal system at the moment, sometimes having to wait 2 or 3 years, that could be a very expensive issue for an employer.
Yeah.
So it does, and there's further amendments to sexual harassment later in the year. So combined, it is a very big area for employers to be careful of.
Yeah. In terms of, I suppose, I think you were chatting to the marketing team ahead of this, and I think one of the things that you mentioned was around whether disclosure would be managed as harassment, grievance, or a whistleblowing concern. Like, how can it fall under 3, or would it fall under 1, or how does that work?
Yes, it cannot. So
Right.
the short answer is yes, it can. So they could raise a grievance.
Yeah.
They could say they've made a protected disclosure, and of course they can bring just a general sort of, I think I'm being discriminated against. For employers, though, I think it's not so much, and HR experts, I don't think it's so much what policy it falls under, because you could tie yourself on knots about, what procedure do I, I've got a grievance procedure in the handbook, I've got a whistleblowing policy, etc. It's more like, well, what's the legal protections that the individual has, and therefore how do I deal with that? And practically what I think that means is, as long as you conduct one proportionate investigation, not necessarily badge it in one of those 3 things, but make sure that you are looking to minimise the risk of any of those types of claims, so whistleblowing, discrimination, etc. That's the important thing. So, listening to the employee, sitting down with them, maybe interviewing other people, and really sort of coming to a sensible, reasonable conclusion, and communicating back to the individual. That's much more important than worrying too much about the badge you associate with it.
Yeah. Okay. And I suppose, look, is this again? This is more responsibility on managers, right? I'm assuming this is like HR obviously going to be aware of this, but it's more about the managers than it is HR sort of knowing and understanding these rules.
Yes, and some legislation changes came in back in 2024 actually. So we were telling them, employers and clients then that they had to be looking at this with their managers, but it's even more essential now, Stuart. That you're absolutely right that it's at the coalface, because usually it's quite common for an individual not necessarily to go off to HR. And for smaller businesses, you may not even have an HR department. They're going to go to their line manager or senior manager. And yes, it's those managers that need to know how to deal with when those concerns are raised. So training is absolutely essential.
I think I feel more sorry for managers than I do maybe HR with some of these changes in legislation. Like, it's because I suppose they're the ones that are going to see it. If it happens every day, they're the ones managing teams where this is going to impact. It's a lot of responsibility.
Yeah. It is. Yeah, it always has been. Unfortunately, that as employment law's grown since it first came in the early 70s. Unfortunately, it is the case that obviously, if you've got good HR behind you supporting you, then that should help. So I don't want to take away from that. But yes, managers really do need to, be aware. I always say to people, if in doubt, ask. Whether it's your internal HR or whether it's someone external, an expert externally. Don't be afraid to do that, rather than trying to second guess.
Yeah, it's. I suppose I only just raised that a little bit because I talk a lot on podcasts with say people in sort of leadership and development, etc. And they talk a lot about the accidental manager, people that have fallen into this because they're good at say maybe an individual contributor role, and they go into them being a manager without thinking about things like this. You don't go into management thinking this is what you're going to have to deal with. You go into management because you enjoy the job that you do.
Yeah, and you're good at it. Yeah, I have to say, Stuart, that historically, and some of my solicitor colleagues out there might not necessarily like this, but it's my experience. Law firms were almost some of the worst at this because what would happen historically is, obviously you had billing targets, etc. And if you were good at your job, you got promoted up, you'd suddenly have a team below you, but you wouldn't necessarily get the training to help you support that team. And I would say the legal sector wasn't necessarily, was probably one of the worst ones certainly historically. Yeah. So I know exactly what you're talking about.
Yeah, and I suppose like good HR functions, are they the ones that I don't know? They're the ones that maybe are not just saying I'll do a training session, I'm done. They're the ones that are sort of continually educating and supporting on things like this. Because again, I can imagine being a manager and you go to sort of do some training on this. It goes in one ear and out the other in the first round. It's really hard to sort of remember all this stuff on top of the day job.
Yeah, and you're not going to remember, especially as time goes on, because you'd hope that a lot of these issues only come up very occasionally, if at all. And if you had your training 4 years ago, you could be like, no, I can't remember. So it's constant, and sexual harassment training, which, as I said, since 2024, dare I say, employers should be doing anyway. It has to be regular. It should be, every year, every 18 months, even if it's just a refresher, and obviously not as detailed as the initial induction training. It's really key.
Yeah, completely agree. Now, you mentioned this at the start of the call again. I want to talk about the Fair Work Agency, because I have to say this is something I had not really heard of before. Do you want to tell us what it is and what it's designed to change?
Yeah, of course. So the Fair Work Agency is a brand new body that's come into force from April this year. So historic, and it's all about enforcing individuals' rights against their employers who have done things wrong in certain areas. So historically, it was, you had a claim, maybe you succeeded with it in a tribunal, and then the employer doesn't pay. Or it could be that you've raised it with HMRC about national minimum wage, and your employer doesn't pay once it's determined. That was the issue. There were several different bodies to go to for different things. So as I said, if it was national minimum wage, it was HMRC. If it was employment agency standards, then you had to go to the what's called Employment Agency Standards Inspectorate. If you were working under a gangmaster, you had to go to the Gangmasters and Labour Abuse Authority. Some of these things I hadn't heard of years ago. And so it's very confusing for not only was it very confusing for individuals, but more importantly, it was difficult, and so often people would just give up. And the statistics on awards not being paid by employers were high. So anyway, this government decides to bring in the Fair Work Agency, and first thing it does, it's a single enforcement agency. So it brings all those things I just mentioned, which were fragmented before, under this one new body. But this body also has extra powers. So rather than just sort of enforcing awards against employers who have breached national minimum wage, for example, or abusing, exploiting people and not having the right licenses for their workers. Not only do they can investigate and enforce action, but for the first time, pretty much in employment law, they can actually bring claims on behalf of individuals.
Right.
So, they can go to tribunal on behalf of an individual, for example, who hasn't received their national minimum wage. At the moment, it is restricted to those areas that I've just said, but over time, it's going to be expanded. We've been told by the government to things like unpaid holiday, which of course has been a big issue over the years. So yeah, it's obviously too early to say how effective it will be. I don't know how well it's resourced by the government, but yeah, it's now in play from April.
Yeah, I didn't know too much about this at all, and when I started looking into it, I even found out that it sort of takes over the Employment Agencies Act as well in terms of conduct and regulations for recruitment agencies.
Yes.
So there's a lot there that falls under this that I genuinely wasn't aware of.
Yeah, that's right. Yeah. And as I say, the employment agency, as I say, was the standard authority before. Now it comes under the Fair Work Agency. Yeah, and as I say, they have increased powers. And of course, they can impose penalties and fines of their own as well. So yeah, it's something you need to be aware of.
Yeah, completely. And look, this is part one of the conversation that you and I are having. So I want to wrap up part one with a sort of a final question for you. Like in terms of, so I suppose, advice around these changes, if you were sort of talking to HR people at the moment and they're a little bit nervous about what was happening, what advice would you give them at the minute?
We talked about this quite a bit up to now. I think the big mistake that some have made in the past is treating all these legislation changes in employment law as just legal updates. Oh, we'll just update our policies and leave it at that. It's more treating it as an organisational change and management risk, as I mentioned earlier. So it's all about focusing on your manager's capability, how to deal with all these issues. Because as you said earlier, Stuart, it's there's so much to try and remember and think about, and there's more and more things that your staff can come to you about with concerns and issues. So it's really about focusing on that side of things. And of course, and I said this about earlier, don't be afraid to look for help, whether it's internally or there's lots of external help out there as well. So if in doubt, ask, the old adage.
Yeah, and I suppose just a question business-wise for you, is this resulting in business for you? Are you doing a lot of this sort of training and development for organisations at the minute?
Yeah, so right from doing the contractual changes and handbook changes, but yes, also we do training. So we do the sexual harassment training, for example. As I said, that's really important now. And just advising clients on a day-to-day basis, really, because no one can remember everything, and your most experienced HR or managers will need assistance. So, yeah, that's cynically, you could argue is giving us more work, and we're certainly very busy now.
Yeah, nothing cynical about it. I think this is one of the arguments that a lot of businesses have, isn't it, on changes? It makes work more complex or more complicated, which means expertise like yourself is ever more in need when changes like this happen. So look, I think it's something that's really important. But look, I want to thank you for your time, because obviously this is just part one, as I said, of two parts that we're going to go to. So look, thanks so much for your time today, Paul. It's been a real pleasure to talk to you, and I look forward to talking to you on our next episode.
Yeah, thanks, Stuart. It was great, and I'll speak to you soon.
Perfect.
Thank you.
Thank you for listening to today's show. I will highlight that this is part one of a two-part series that we're covering on employment law. Please listen in next week for the second episode.
If you want to stay up to date with our content, please register to HR Insights via our website. Elliott Scott, the exclusive HR search and recruitment partner for HR leaders and professionals across the globe.